So the old saying that a grand jury will indict a ham sandwich apparently does not apply to salami sandwiches. For the second time in recent weeks, a grand jury in D.C. has failed to indict a defendant. Not once, but multiple times this is happening. A previous defendant, they tried over and over again to indict them. The grand jury would not do it. What's going on with D.C. grand juries? Are prosecutors even allowed to keep trying? Is that double jeopardy? Let's break it down. But before we break it down, let me remind you to hit that subscribe button. Make us the biggest and best legal analysis and political analysis channel that there is. I mean, we're already that, but let's get even bigger. So recently, you may remember that President Trump, who likes to call himself the chief law enforcement officer, maybe the cop in chief, said he had instructed the police to do whatever the hell they want, and claiming that police no longer have to tolerate being spit at. Now, they didn't have to tolerate that to begin with, because in most jurisdictions, spitting on someone is a crime anyway. But let's take a look at how federal law enforcement, DC, big federal takeover right there, lining the streets with federal police, FBI, ICE, of course, everybody. Let's take a look at how they're reacting to this new directive by the cop in chief.
Go fucking way! You bitch!
Motherfucker! Oh!
Oh! Oh! It's fucking gun! Fucking gun! Fucking gun!
He cooked him! He cooked him!
So I guess throwing a Subway sub is not the same as spitting, as they didn't immediately hit back. But they did chase him to arrest him, which is maybe understandable. But note how he threw it. I mean, take a look at that video. It's all over the internet. He's there yelling, holding the sandwich. He's not trying to hit anybody with a sandwich. He's been yelling for a while. He's, visibly pissed off at the police, making a point. And then he quite clearly throws it not at the face of the officer, not even particularly hard. He throws it not so hard at the armored part of what appears to be an FBI agent from his uniform. Now, who might have been an FBI agent standing there on the street? Well, probably it was the FBI police, not an agent being forced to stand around on the street. But in any event, they chase him. And they're kind of slow in the chase, right? He's not really like making world record sprint class, but they're chasing the guy with like body armor, guns, Kevlar vests, radios. I mean, typically these guys are running around with stuff that weighs them down by an extra 20 to 40 pounds. But obviously that equipment offers tremendous protection from salami sandwiches being thrown at a low velocity. Nonetheless, they catch the guy. He's arrested. They want to charge him with a felony assault, and they bring him to the grand jury. And the grand jury refuses to indict the defendant, just as they did in the case of a woman previously arrested for allegedly injuring an FBI agent during a protest last month. That grand jury 3 times refused to indict her. And ultimately, the prosecutors in the U.S. Attorney's Office reduced it to a misdemeanor charge, because for a misdemeanor charge, which is typically has to be less than a year of the potential penalty, and most misdemeanors in D.C., just trivia point, are only 6 months, which allow them to be tried by a judge, not even a jury, most of them. They don't need grand juries to charge misdemeanors because they aren't indictments. For an indictment, a felony, you need a grand jury to indict. So a couple of things about grand juries here. First of all, the standard that they're using is so low. It's just probable cause. And the U.S. Attorney's Manual, that's the DOJ manual instructing federal prosecutors, says that the role of the grand jury is 2 things. They can either indict or they can not indict. That's called returning a no bill. And while sometimes the manual notes that grand juries are sometimes described as performing accusatory, investigatory functions, that's all true. But the grand jury's principal function is to determine whether or not there is probable cause to believe that one or more persons committed certain federal offenses within the venue of the district court. Thus, quoting here, it has been said that a grand jury has but 2 functions: to indict or in the alternative, to return a, quote, no bill. So let me tell you a little bit about what it's like in the grand jury, how it works. It's totally different than a trial. Nothing to do with it. You walk into a big room, kind of like a classroom. In DC, the jurors were usually sitting like in tiers, like in a classroom type of rows. Sometimes there's just a big table. In the federal courthouse, more old-fashioned. Sometimes there's just a large room with a big table. Grand jurors are just sitting around, drinking coffee, eating their lunch, eating snacks. There's no judge. There's no defense attorney. There's no cross-examination. It's just the prosecutor presenting evidence, usually through a summary witness. Typically, you'd put on an officer, police officer, federal agent. Here's the question. Could you state your name for the record? States their name. On such and such a date, in such and such a place, did you witness the defendant do blankety blank blank and blank? Yes, that's kind of it. You can feed them the whole answer to the questions because leading questions are allowed. I mean, who's going to object to it anyway? No judge, no defense counsel. And then you basically just ask them, in a case like this, I would imagine the questioning goes like, did you witness on this date the defendant throw a salami sandwich? Yes. That's about the end of the presentation for the sandwich throwing case. I mean, I guess they could play the video as well. It's majority vote only. Certainly not unanimous. I mean, that grand juries indict, it's like by one vote kind of majority vote. Case after case after case they listen to. In the Superior Court grand juries, all the felonies in the city, they're on the term that they set for. They sometimes come in 3 days a week. They're hearing dozens of cases all the time. I'll tell you, it's kind of tedious for them. In the beginning, new grand juries, we don't like new grand juries for your prosecutor because they're totally into it. They're asking tons of questions. By the end of the term, they're like 0 questions. They could care less. They just want to get out of there and they'll vote to indict. You can see why they vote to indict, right? I mean, where's the other side's point of view being presented? There's none. No counter arguments, no question by the other side. Of course, they're going to indict the proverbial ham sandwich. So what happens if they refuse to indict? If it's no billed, there's no majority vote. After all, it's only probable cause, not beyond a reasonable doubt. But if they don't do it, that's the end of the case, usually. Now, there is no double jeopardy here, okay? Double jeopardy only applies when a petit jury, that's the kind of small jury you see for a criminal trial, when they've been sworn in, that's what we call jeopardy attaching. That's a really big deal in criminal trials, right? Because once jeopardy is attached, if something goes wrong in the case, this is a big problem. Certainly, if there's an acquittal, you can't retry it. Double jeopardy prevents that. Irrelevant in grand juries. It's not a trial. It's one-sided, no judge, no defense. It's just one-sided. So prosecutors can try again. But take a look at what the grand jury, the U.S. Attorney's Manual says about trying again. We'll put it up for you. Approval required prior to resubmission of same matter to grand jury. Once a grand jury returns a no bill or otherwise acts on the merits in declining to return an indictment, the same matter should not be presented to another grand jury or resubmitted to the same grand jury without first securing the approval of the responsible United States attorney. That's the United States attorney, not just, the assistant prosecuting the case. I can tell you that the supervisors I had would not bother the United States attorney to ask for permission to resubmit a no bill unless it were a major case. This was not a major case. But in this case, they're probably going to end up just charging a misdemeanor, which is probably what it should have been at most to begin with. But in its own way, it is a major case because it is so rare what happened here for grand juries to refuse to return the indictment, even rarer for the government to keep trying or to try again. In the time I was a prosecutor, if there's no bill, I'd never heard of it being resubmitted. That was the end of the case. Why would you resubmit it? Is there new evidence, more testimony? Here, what would they present? There's really nothing else they could do here. I mean, maybe if it didn't play the video, they'd play the video now. But there's nothing new to present. There's no real grounds to try it again. But the case is significant because it says something about what people are thinking, what they're feeling, what they're doing in D.C. You put citizens on a jury, grand jury or petit jury, to give them a voice, to give them power as the Constitution envisioned us to have. That's the power that these grand jurors, these citizens exercised when they were put in that position. That's the power Trump and his regime want to take away from us. I'll leave you with this image and a thank you to the citizens for doing their job. All right, we'll talk to you soon.
I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.